the laws of Arkansas that if you're living with an unmarried partner, then you're considered to be living with an unmarried partner, so be careful about that. So he filed another lawsuit to challenge that new law. And this case was brought on behalf of a number of families who were affected by the law, including Sheila Cole and her granddaughter. Because of the cohabitation ban, Sheila was not permitted to adopt her baby granddaughter, who had been taken into state custody because of severe abuse by her parents. The Arkansas Department of Children and Family Services agreed that Sheila was the right placement for her granddaughter, but could not approve the adoption because of the ban. Other plaintiffs in the case are Wendy Rickman and Stephanie Huffman, who already were approved by the state of Arkansas to adopt a child several years ago and did adopt a child. And now they're ready to open their home and family to another child and have said they would welcome a special needs child. But the ban takes this incredible opportunity for permanency away from Arkansas's waiting children. Interestingly, as in Florida, the state child welfare officials in Arkansas have also acknowledged that this ban does nothing to promote the interests of children. And the case is set to go to trial this May, and like the other cases, will involve extensive expert testimony, so stand by there. So all of this is to say is that we've been going to court to try to deal with this problem in the states where there's a target to shoot at, so to speak, right? An express policy statute that prohibits across the board adoption or fostering by gay people. And we've been having some success in recent years, but I think as the description of these cases probably makes clear, litigation really isn't the way to fully resolve this issue. I think it probably was clear from my description that these cases are incredibly costly and well beyond the means of virtually any individual who is seeking to adopt or foster a child. Just the expert costs alone would be prohibitive, not to mention the attorney time over many years of litigation. So it's just not possible to bring these cases every time you have an incident of discrimination against the prospective foster parents or child denied a possible placement. We can go after the blanket policies like Florida's and Arkansas, but it's very hard elsewhere. And then the related issue is in the states that don't have a blanket policy or a written policy, you don't always know the discrimination is happening or have proof of the discrimination. So litigation really can't solve the problem in those majority states that way. Of course, we don't know how these cases will ultimately turn out, but another obstacle to litigation is that something that makes litigation sort of not the final solution here is that even when we do prevail, as we saw in Arkansas, then we may face new restrictions to get around a favorable court decision. After 7 years of litigation and a unanimous state Supreme Court decision in Arkansas, we now have another lawsuit that's going to take several more years and cost another small fortune to litigate. So litigation can be extremely effective and chip away at this problem and hopefully in some states resolve the issue, but it's certainly not the answer and can't fully resolve this problem by any stretch. And a more global solution like this bill is what we need.